Polygamy is a term that describes the practice of having more than one spouse at the same time. While it often brings to mind images of a man with multiple wives, a practice known as polygyny, it can also refer to polyandry, where a woman has multiple husbands. Around the world, this form of marriage is not widespread. In fact, research shows that only about 2% of the global population lives in households where polygamy is practiced. It is most common in parts of sub-Saharan Africa, where it is often tied to cultural and religious traditions. In many of those countries, the practice is legally recognized, existing alongside monogamous marriage laws and creating a complex legal and social fabric that varies from one nation to another. In the Americas, the story of polygamy is vastly different. From the northern reaches of Canada down to the southern tip of Argentina, the practice is almost universally illegal. North, Central, and South American countries have laws that strictly define marriage as a union between only two individuals. This legal uniformity reflects a shared cultural and historical background, heavily influenced by European colonial powers and Christian traditions that have long championed monogamy as the sole legitimate form of marital union. The laws are not just on the books. They are deeply embedded in the social and legal structures of every nation in the hemisphere, making the idea of multiple spouses a foreign and often condemned concept. Despite its illegality, polygamy does exist in small, often isolated pockets throughout the Americas. These communities are typically formed around specific religious beliefs that diverge from mainstream society. They often live in secrecy to avoid legal prosecution and social stigma, creating worlds unto themselves where their practices can continue away from the watchful eye of the law. These groups, sometimes called fundamentalists, believe they are following a higher divine law that supersedes the laws of the state. Their existence creates a constant tension between religious freedom and the government's duty to enforce its laws, particularly when concerns about the well-being of women and children within these communities arise. The legal battles and social debates surrounding polygamy in the Americas are therefore not just about marriage. They touch upon fundamental questions of individual liberty, religious expression, and the state's role in protecting its most vulnerable citizens. As societal views on relationships and family structures evolve, these conversations continue to challenge long-held beliefs. While the laws remain firm, the ongoing dialogue forces us to examine why these prohibitions exist and whether they continue to serve their intended purpose in a changing world. It is a complex issue where deeply held faith collides with the established legal order, raising questions that have no easy answers. In the United States, the law is unequivocally clear. Polygamy is illegal in all 50 states and its territories. This nationwide prohibition is rooted in federal legislation dating back to the 19th century, most notably the Edmunds Act of 1882, which made polygamy a felony. This law was specifically aimed at the early practices of the Church of Jesus Christ of Latter-day Saints, also known as the Mormon Church, which has since officially disavowed polygamy. Today, every state has its own laws that criminalize bigamy, which is the act of entering into a marriage while still married to another person. The penalties for violating these laws can be severe, ranging from hefty fines to significant prison sentences, reinforcing the country's legal commitment to monogamy. Enforcement of these anti-polygamy laws is primarily a state-level responsibility, and how aggressively they are pursued can vary. For many years, authorities often took a hands-off approach, choosing not to prosecute consenting adults in polygamous relationships unless other crimes, such as welfare fraud or abuse, were also involved. This reluctance stemmed from the complexity of the cases and a desire to avoid appearing to persecute people for their religious beliefs. However, this approach has been challenged by growing concerns about the potential for exploitation within closed polygamous communities, pushing law enforcement to take a more active role in investigating and prosecuting these cases where harm is suspected. The legal foundation for the ban on polygamy was solidified by the Supreme Court in the 1878 case Reynolds v. United States. The court ruled that while the government cannot legislate belief, it can regulate actions, even those motivated by religious conviction. This landmark decision established that the First Amendment's protection of religious freedom did not shield the practice of polygamy from criminal law. The court argued that allowing polygamy would disrupt the social order, which it viewed as being founded upon the institution of monogamous marriage. This ruling has remained the bedrock of American anti-polygamy law for over a century, providing a powerful legal precedent that continues to guide courts today. Despite the solid legal prohibition, social attitudes have been slowly shifting. Recent polls indicate a growing minority of Americans find polygamy to be morally acceptable, a significant increase from just a couple of decades ago. This change is more pronounced among younger and more liberal demographics, suggesting a broader evolution in how society views non-traditional relationships. However, this shift in public opinion has not translated into any meaningful push for legal change at the federal or state level. The legal framework remains firmly in place, and the vast majority of the public and lawmakers continue to support the long-standing ban on having more than one spouse. Utah, a state with a deep and complicated history with polygamy, made a significant legal change in 2020. Lawmakers decided to reduce the penalty for practicing polygamy among consenting adults. What was once a felony, punishable by up to 5 years in prison, is now treated as a simple infraction. This is similar to getting a traffic ticket. The new law means that a person found in a polygamous union can be fined up to $750 or ordered to perform community service, but they will not face jail time. This move was not an endorsement of polygamy. The practice remains illegal under the state's constitution. Instead, it was a strategic decision designed to address a long-standing problem. The primary motivation behind this change was to encourage people within polygamous communities to report crimes without fear. For decades, victims of abuse, such as domestic violence or child exploitation, were hesitant to go to the police. They worried that by reporting one crime, they would expose themselves and their entire family to prosecution for polygamy. This created a wall of silence that allowed more serious offenses to go unpunished. Supporters of the new law argued that by decriminalizing the act of cohabitation itself, it would become easier for individuals, especially women and children, to seek help and for law enforcement to investigate and prosecute genuine cases of harm. The bill's passage was the result of a surprising alliance. It brought together former members of polygamous groups who shared harrowing stories of abuse, and civil liberties advocates who argued that criminalizing the lifestyles of consenting adults was an overreach of government power. This coalition convinced lawmakers that the old approach was not working. They contended that driving polygamous families further into the shadows only made them more vulnerable to exploitation. The new law, they hoped, would build trust and open lines of communication between these isolated communities and the outside world, making it harder for predators to operate with impunity. However, the change was not without its critics. Some opponents worried that reducing the penalty would be seen as a green light for polygamy, potentially leading to an increase in the practice. They argued that the felony-level threat was a necessary deterrent to a lifestyle that they believe is inherently harmful to women and children. Despite these concerns, the law passed with strong bipartisan support. It represents a pragmatic shift in strategy, moving the state's focus from punishing the practice of polygamy itself to targeting the associated crimes like fraud, sexual assault, and human trafficking. The long-term effects of this Utah experiment are still being watched closely by other states and legal experts. In Canada, the legal position on polygamy is just as firm as it is in the United States. Section 293 of the country's criminal code explicitly outlaws all forms of polygamy, making it a criminal offense to be in a union with more than one person at a time. A separate section, 290, specifically bans bigamy. These laws have been part of Canada's legal framework for a very long time, reflecting a societal and legal tradition that recognizes only monogamous marriage. For many years, however, these laws were rarely enforced. There had not been a successful prosecution for polygamy in over 6 decades, which led to a great deal of legal uncertainty about the law's validity in the modern era. This uncertainty was particularly relevant in the community of Bountiful, British Columbia. Bountiful is home to a fundamentalist sect that broke away from the mainstream Mormon Church and continues to practice polygamy. For years, the community lived in relative isolation, and while their practices were well known, legal attempts to prosecute leaders for polygamy failed. In 2009, 2 prominent leaders from Bountiful were charged, but the case was ultimately thrown out on technical grounds. This failure prompted the government of British Columbia to seek clarification from the courts, wanting to know once and for all if the law against polygamy was constitutional or if it violated the religious freedom guarantees of the Canadian Charter of Rights and Freedoms. The lack of enforcement created a difficult situation for both law enforcement and the residents of communities like Bountiful. Police were hesitant to lay charges that might not hold up in court, and the legal ambiguity left many people within these communities, especially women and children, in a vulnerable position. Without clear legal action, concerns grew about potential harms associated with the practice, such as the marriage of underage girls, the subjugation of women, and the psychological impact on children growing up in large, complex family structures. The failed prosecutions highlighted the need for a definitive legal ruling to guide future actions. The Canadian public has remained largely supportive of the ban on polygamy, viewing it as a practice that runs counter to the nation's values of equality and individual rights. While Canada is known for its multiculturalism and protection of religious freedoms, there has been a strong consensus that these freedoms have limits, especially when they may lead to harm. The legal gray area that existed for so long was seen by many as an unacceptable gap in the protection of citizens. This public sentiment provided a strong backdrop for the legal challenge that would eventually make its way to the Supreme Court of British Columbia, setting the stage for a landmark decision. The legal uncertainty in Canada came to a head in 2011 with a landmark decision from the Supreme Court of British Columbia. After a lengthy and detailed reference case, the court upheld the constitutionality of Canada's anti-polygamy law. The Chief Justice who presided over the case concluded that the law was a justifiable limit on religious freedom. The core of his reasoning was what he termed a reasoned apprehension of harm. The court heard extensive evidence from academics, former members of polygamous communities, and social workers. This testimony painted a picture of polygamy not as a harmless lifestyle choice, but as a practice frequently linked to significant physical and emotional damage. The court identified several specific harms associated with polygamy. These included higher rates of physical and emotional abuse of women, competition and conflict among wives, and negative outcomes for children. Children in polygamous families were found to face higher rates of poverty, educational neglect, and psychological problems. The court also heard disturbing testimony about the practice of assigning young girls, some well under the age of consent, as wives to older men within these communities. The ruling made it clear that the state has a compelling interest in protecting women, children, and the institution of monogamous marriage itself from these documented harms. Importantly, the court's decision also provided guidance on how the law should be applied. The judge specified that the criminal law should not be used to prosecute minors who were forced or coerced into a polygamous marriage. Instead, these young people should be treated as victims. He also drew a distinction between polygamy and polyamory. Polyamory, which involves consensual, non-monogamous relationships among multiple adults without a formal marriage contract, was not the target of the law. The ruling clarified that the law was aimed at the formal institution of polygamous marriage and the harms specifically associated with it, not private relationships among consenting adults. This ruling was a pivotal moment for Canadian law. It gave governments and police the legal confidence they needed to enforce the ban on polygamy. Following the decision, charges were once again laid against leaders in the Bountiful community, and this time, they resulted in convictions. The British Columbia Supreme Court's decision sent a powerful message. While religious freedom is a fundamental right in Canada, it is not absolute. When a practice, even one rooted in deeply held religious belief, causes demonstrable harm to individuals and society, the state has the right and the responsibility to intervene and uphold the law. Moving south into Latin America, the legal stance against polygamy remains consistent. Throughout Central and South America, marriage is legally defined as a monogamous union, and laws prohibiting bigamy are common. Brazil, the largest country in the region, provides a clear example of this legal framework. Under Brazilian law, bigamy is a crime. Any citizen who marries a second person while still legally married to the first can face a prison sentence of 2 to 6 years. This law applies to all Brazilians, including those who have become naturalized citizens, ensuring that the principle of monogamy is upheld across the board. However, the situation in Brazil reveals a subtle but important distinction in the law. While formal, legally registered polygamous marriages are strictly forbidden and criminally prosecuted, the law is silent on what is known as de facto polygamy. This refers to situations where a person cohabits with multiple partners without entering into any legal marriage contracts. These informal, multi-partner households are not explicitly outlawed. This legal loophole means that while a person cannot have more than one legal spouse, they are not necessarily breaking the law by living with and maintaining relationships with multiple partners, as long as these unions are not formalized through the state. This distinction has led to some interesting and complex social and legal situations in Brazil. There have been cases where informal three-person unions have sought legal recognition, not as marriages, but as civil unions for the purposes of shared health benefits, inheritance, and other rights typically granted to couples. In one notable instance, a notary public controversially registered a civil union between three people, sparking a nationwide debate. However, Brazil's National Council of Justice later ruled against such registrations, reaffirming that the legal system is designed to recognize unions between only two individuals, thereby closing the door on any official recognition of multi-partner relationships. The broader cultural and social context in Brazil, as in much of Latin America, is heavily influenced by the Catholic Church and conservative social values. These forces strongly support the traditional, monogamous family structure. While society is becoming more diverse and conversations about different family arrangements are emerging, there is very little public or political appetite for legalizing polygamy. The laws are seen as protecting a fundamental pillar of society. As a result, the legal prohibition on bigamy remains firmly in place. And while informal arrangements may exist in the private sphere, they have no standing in the eyes of the Brazilian state. To understand the real-world impact of polygamy laws, one need only look at the Fundamentalist Church of Jesus Christ of Latter-day Saints, or FLDS. This is a secretive and isolated offshoot of mainstream Mormonism that continues to practice polygamy. Their largest communities are located in places like Short Creek, a remote area straddling the border of Utah and Arizona. For generations, the FLDS has operated as a society unto itself, with its leader, the prophet, holding absolute authority over the spiritual and daily lives of his followers. Men in positions of power are often assigned multiple wives, while women are taught from birth that their divine purpose is to obey and enter into these plural marriages. Life within these communities is often marked by extreme control and a lack of individual freedom. The group's leader, Warren Jeffs, who is now serving a life sentence for child sexual assault, exerted total control over his followers. He dictated who could marry whom, when, and at what age. This system has been linked to systemic human trafficking and the exploitation of children. Reports and testimonies from former members describe a culture where girls as young as 12 or 14 were forced into celestial marriages with much older men, who were often their relatives. These girls were treated as property, their futures decided for them by church elders. The secretive nature of these communities makes it incredibly difficult for outsiders, including law enforcement, to intervene. Children are often born at home and are not issued official birth certificates, making them invisible to the state. This lack of documentation makes it nearly impossible to track their well-being, school attendance, or even their existence. Young men who are not chosen for marriage are often cast out of the community, left to fend for themselves in a world they are completely unprepared for. These lost boys, as they are known, are often left with little education and no support system, another tragic consequence of the community's rigid structure. The stories that have emerged from former FLDS members paint a harrowing picture that stands in stark contrast to any romanticized notion of polygamy. They speak of a system built on power and control, where the desires and well-being of individuals, particularly young women, are sacrificed for the benefit of a few men at the top of the hierarchy. These real-life examples are a major reason why the laws against polygamy exist, and why they are so fiercely defended. They illustrate the profound potential for harm that authorities and lawmakers cite as the primary justification for prohibiting the practice, shifting the debate from one of religious freedom to one of fundamental human rights. The legal prohibitions on polygamy across the Americas are not arbitrary. They are built upon a foundation of specific concerns, with the primary justification being the protection of women and children from harm. Courts and legislatures have consistently argued that polygamy, as it is often practiced, leads to an environment of inequality and exploitation. In many polygamous structures, particularly those seen in fundamentalist groups, women are not equal partners. They are often relegated to a subordinate status, competing for the attention and resources of a single husband. This dynamic can lead to emotional distress, jealousy, and a lack of individual autonomy, as their lives are largely controlled by their husband and the group's hierarchy. Beyond the impact on women, the well-being of children is a central argument used to justify the ban. Studies and testimonies presented in legal cases, such as the one in British Columbia, have shown that children raised in polygamous households can face significant disadvantages. They often experience higher levels of poverty because a single father's income must be stretched to support multiple wives and a large number of children. This can result in neglect, inadequate healthcare, and limited educational opportunities. Furthermore, the complex family dynamics can create emotional and psychological challenges as children navigate relationships with numerous half-siblings and mothers in a competitive household environment. Another key argument against legalizing polygamy is its potential to damage the institution of monogamous marriage, which the law has long held up as a cornerstone of social stability. Proponents of the ban argue that marriage is not just a private contract between individuals, but a public institution that serves broader societal functions. They contend that monogamy promotes gender equality and creates a stable environment for raising children. The fear is that legalizing polygamy would undermine this structure, leading to a host of negative social consequences. This argument frames the debate not just around individual rights, but around the preservation of a social order that is seen as beneficial for society as a whole. Finally, the connection between polygamy and other serious crimes provides a powerful reason for its prohibition. In practice, especially within closed and authoritarian communities like the FLDS, polygamy has been inextricably linked to welfare fraud, tax evasion, and most alarmingly, child sexual abuse and human trafficking. Law enforcement and prosecutors argue that the practice of plural marriage in these contexts is often a cover for the systematic exploitation of minors. By maintaining a strict legal ban on polygamy, the state retains a crucial tool for investigating and dismantling these criminal enterprises, allowing authorities to intervene in situations where fundamental human rights are being violated under the guise of religious practice. In the vast expanse of the Americas, the legal status of polygamy is remarkably consistent and clear. It is against the law. From Canada's criminal code to Brazil's statutes on bigamy, and the long-standing federal and state laws in the United States, monogamy is the only legally recognized form of marriage. This legal uniformity is a reflection of shared historical, cultural, and religious traditions that have shaped the hemisphere for centuries. While isolated communities continue to practice polygamy in defiance of the law, they remain on the fringes of society, their way of life existing in the shadows. The practice is exceedingly rare, with less than 0.5% of the population in any American nation living in a polygamous household. The legal battles that have been fought, from the United States Supreme Court in the 19th century to the courts of British Columbia in the 21st, have consistently reaffirmed the state's right to prohibit polygamy. The core justification has remained unchanged: the prevention of harm. The courts have been persuaded by evidence linking the practice to the systemic disempowerment of women and adverse outcomes for children. The stories emerging from communities like the FLDS, filled with accounts of coercion, child marriage, and abuse, have provided a stark and powerful testament to the potential dangers, reinforcing the legal and social consensus against the practice. Even recent legal shifts, such as Utah's decision to decriminalize polygamy among consenting adults, do not signal a move toward legalization. Rather, they represent a tactical change in enforcement, aimed at making it easier to prosecute associated crimes like abuse and fraud. The goal is not to legitimize polygamy, but to better protect the vulnerable individuals within polygamous communities. This pragmatic approach underscores the fact that the fundamental opposition to the practice remains. Lawmakers are focused on addressing the negative consequences of polygamy, not on dismantling the legal barriers that surround it. For these reasons, the legal horizon for polygamy in the Americas is unlikely to change anytime soon. Despite a modest increase in social acceptance in some polls, there is no significant political or public movement to legalize plural marriage. The legal precedents are strong, the social and cultural opposition is deeply entrenched, and the documented harms associated with the practice provide a compelling reason for the state to maintain the ban. The law across the Americas will, for the foreseeable future, continue to reflect the deeply held belief that marriage is a union between two people and two people alone.